Hello, everyone. Welcome to When Seeing Isn't Believing, Challenging Visual Evidence in Modern Prosecutions. I'm Jan Goldstein, co-chair of BHBA's Criminal Law section. I'm delighted to introduce you to our speaker, Duncan Levin. Mr. Levin is the managing partner of Levin Associates, a former federal prosecutor and a former chief of asset forfeiture at the Manhattan District Attorney's Office, where he oversaw a landmark financial enforcement matter, including the 1.9 billion HSBC OFAC sanctions forfeiture. He represents individuals, executives, and companies in white-collar criminal defense, fraud and regulatory investigations, sanctions, and asset forfeiture litigation, and complex high-stakes matters where investigative, reputational, and commercial pressures intersect. Mr. Levin also serves as a lecturer on law at Harvard Law School and Columbia Law School, and is a frequent legal commentator on CNN, MSNBC, and NBC. And now, without further ado, let's get started.
Thank you so much, Jan. I very much appreciate it. Good afternoon, everybody. I am Duncan Levin, and this presentation is called Visual Proof in the Age of AI. The title sounds a little futuristic, but it's not futuristic at all. It's already here. Every lawyer who litigates, investigates, advises clients, or evaluates risk is now dealing with visual evidence in some form. And that may mean that photographs and screenshots, surveillance video, body cam footage, doorbell camera clips, all the things we're dealing with in court, social media posts and Zoom recordings and cell phone videos, all of these different things we're all dealing with them. And for a long time, lawyers and courts have treated visual evidence as unusually powerful because it appears to speak for itself. Somebody shows a photograph and says, this is what happened. Somebody plays a video and says, there it is. A jury sees the image and immediately begins to form a view of the facts. And that's always been very powerful, but it's also been dangerous because a photograph is not the event itself. A video is not the event itself. A screenshot is not the conversation itself. Each one is a representation. It has a source, it has a frame, it has a beginning and an end. It may have been compressed or cropped or edited or enhanced or stripped of metadata. And it may be reliable or it may not be. But it should never be treated as self-proving just because it looks convincing. Artificial intelligence makes this problem sharper. The point is not really that every image is now fake. That would be wrong and not useful. The point is that the old courtroom instinct, I can see it, therefore it probably happened, is becoming less safe. Generative AI changes the economics of fabrication. It makes it cheaper and faster and easier to create or alter images or audio or video. I'm in New York. You guys are in Beverly Hills. You know better than me what's going on at some of these Hollywood studios. You don't need any longer a Hollywood studio or a sophisticated forensic background to create something that looks polished or realistic or emotionally persuasive. A party, a witness, an adversary, a client, a social media user, or an anonymous internet source may be able to generate visual material that appears credible before anyone has asked the basic evidentiary questions. So the central theme of this CLE, which we'll be doing for the next half hour, is simple. Seeing is not the same as knowing. The rules of evidence already give lawyers tools for dealing with this. We do not need to invent an entirely new body of law before we can act intelligently. We need to use the existing tools more carefully. And what that means for us as trial practitioners is authentication under Rule 901. It means Rule 403, when visual evidence is more prejudicial or confusing or misleading than probative. It means the best evidence rule, Rule 1002, when the content of a recording or an image is at issue. It means expert testimony under Rule 702, when technical questions exceed ordinary lay understanding. And it means the practical mechanics of chain of custody and metadata and source files and preservation. So one final point at the outset. This presentation itself illustrates the issue. A polished CLE deck about AI and visual evidence can now be created very quickly using AI tools. And that does not make this legal analysis fake, but it does show how quickly visual authority can be manufactured. A slide, an image, a demonstrative, or an exhibit can look professional and credible without necessarily being reliable. And that's really the environment that we now have to litigate in. Let's move to slide 2, please. So I can talk a little bit about what this CLE covers. Okay, a practical roadmap for lawyers confronting visual proof in the age of AI. So here's the roadmap for the next half hour. I want to make 5 main points and then apply them to a practical hypothetical. First, visual evidence is different from ordinary testimony or documents because it feels immediate. Lawyers tend to think in categories: relevance, foundation, hearsay, prejudice, burden of proof, and standard of review, and so on and so on. Jurors don't really often experience evidence that way. I think some of us have been jurors and have heard stories come at us. They're experiencing evidence very differently. They're experiencing evidence as a story. They ask themselves different questions than we do, right? They say to themselves, what do I think happened? Who do I believe? What feels real? And images and videos can answer those questions emotionally before they answer them legally. And that's why lawyers use visuals. And it's also why lawyers need to be careful with them. Second, AI changes the reliability equation. Again, the point is not that fabrication is new, right? People have always staged photos and altered documents and cut videos and created misleading excerpts and fabricated screenshots. The new issue is scale and accessibility. The tools are better, right? The cost is lower. Anyone can do this. The results are much more plausible. And the time required is shorter. And that changes the background assumptions that courts and lawyers bring to visual material. Third, I'm going to focus on familiar evidence rules. It's important because AI does not mean we throw out the rules and start over. The core rules are already there, right? Rule 901 asks whether the item is what the proponent claims it is. Rule 403 asks whether the jury may be unfairly prejudiced or confused or misled. Rule 1002 asks whether we need the original when the content of a recording is being proved. Rule 702 asks whether expert testimony would assist the trier of fact. Fourth, we're going to talk practically about authentication and metadata and chain of custody. This is where lawyers often either solve the problem early or create a problem they cannot fix later. The time to ask about the original file is not the night before trial. The time to preserve metadata is not after a file has been forwarded or texted or downloaded or compressed, right, or uploaded and converted into a PDF. The time to understand what you have is at intake. And fifth, I want to give you sort of a practical litigation playbook. If you're offering visual evidence, what do you need to do to make it admissible and resilient? If you're challenging visual evidence, where do you press? When do you ask for the original? When do you seek metadata? When do you need an expert? When do you move in limine? When is the better argument not this is fake, but this is incomplete and misleading and insufficiently authenticated? That distinction matters, right? Because in practice, the goal is not often, or not always, I should say, to prove that something was AI generated. Because sometimes you can't prove that. You won't be able to prove that. Sometimes it's not even the strongest argument. The stronger argument may be that the proponent has not shown what the evidence actually is, or where it came from, or whether it's complete, or whether it was altered, or whether the jury will understand its limitations. So, as opposed to the way that a lot of people are thinking about generative AI, I think the central question for this CLE presentation is not, does this image look real? I think the better question is, can this image be trusted for the purpose for which it is offered? That is the discipline that lawyers need. Authenticity is not an aesthetic judgment. It is an evidentiary judgment. So that's the roadmap. Let's move on to slide 3, if we can. Why images win. Seeing something is not the same as knowing. Let's start with why images are so powerful. We all know this intuitively. A picture is worth 1,000 words. A witness can testify for an hour, and a juror may still feel uncertain. A lawyer can summarize a document, and a juror may still feel detached, right? But a picture or a video can collapse that distance immediately. And it can make the juror feel present. It can make the juror feel as though they're not being told about an event, but they're experiencing the event directly. And that's why visual evidence can dominate a case, right? A surveillance clip can define a defendant. A body camera video can define an encounter. A screenshot can define a relationship, right? A scene is set by a photograph. A short clip becomes the image that everyone remembers during deliberations. But with that power comes a problem, because visual evidence often feels complete even when it's not complete. A video has a frame, and what is outside the frame may matter. A video has a beginning. What happened before the video started may matter. A video has an end. What happened after the video stopped may matter. A video has an angle. Another angle may show something different. A video may have audio, or it may not. It may be the original, or it may be a copy. It may be a full recording, or a short excerpt, or a raw file, or a compressed export. So when we say the video shows something, we need to be precise. The video may show something, but it rarely shows everything. So think about, for example, a 10-second cell phone clip of a confrontation. The clip may look devastating. One person looks aggressive, another person looks passive. But what if the dispute lasted 30 minutes? What if the video begins after a provocation? What if the person recording had a reason to start at that exact moment? And what if the audio is missing? What if the video is cropped? What if the clip was posted online with a caption that supplies a false narrative? What if the version being offered in court is a screen recording of a repost of the original? So the legal question can't be, does it look bad? The legal question has to be, what exactly is this evidence, and what exactly does it prove? And this is where lawyers need to teach the court, and eventually the jury, to separate seeing from knowing, right? Visual evidence creates emotional momentum. A photograph of injuries and weapons and money and property damage, all this stuff can carry narrative weight far beyond its technical probative value. And it doesn't mean the evidence is inadmissible. It just means we have to be alert to the difference between probative force and emotional force. So Rule 403 is especially important here. Lawyers often think of 403 in terms of gruesome photographs or inflammatory evidence. But visual evidence can be misleading even when it's not gruesome, right? It can be misleading because it is too persuasive. It can invite the jury to stop asking questions because it can make uncertainty feel like certainty. And the age of AI, that concern becomes even more important. The more realistic synthetic media becomes, and the easier it becomes to edit or enhance real media, the more careful we have to be about allowing visual confidence to substitute for proof. So the practical habit I would urge is this: when you encounter visual evidence, don't begin with awe, begin with questions. Who made it? When was it made? Where was it made? What device created it? Is it complete? Is it original? What assumptions will the jury make? And has the proponent actually laid the foundation for those assumptions? Let's go to slide 4, please. So let's turn directly to AI. What I want to talk about is why visual proof is more powerful and more dangerous than ever. The worst way to handle AI in litigation is to say vaguely, well, anything can be fake now, and to tell a jury that, because I don't think that that is a useful legal position. Courts cannot operate on generalized suspicion. Judges are not going to exclude photographs and videos simply because AI exists, nor should they. Real evidence still exists. Real phone videos still exist, right? Real surveillance footage exists. And we shouldn't respond to AI by pretending that nothing can be trusted anymore. And a jury is very likely to reject that if that's what you tell them. I think the better point is narrower and more useful. AI changes what a reasonable lawyer should ask before trusting visual evidence, right? Historically, high quality manipulation was much harder, right? It required skill and time and very often expensive tools. So there were still fakes, of course. There were staged photographs and edited tapes and altered documents and fabricated screenshots, misleading excerpts. But the baseline assumption was that a realistic video of a person doing or saying something was hard to fake convincingly. That assumption is weaker now. AI tools can create realistic faces and realistic voices and plausible backgrounds, synthetic documents and altered videos, right? And they can clean up things. They can clean up audio and sharpen video and images and interpolate frames, remove objects, add objects. We've probably all played around with ChatGPT doing that ourselves. And this creates several categories of concern, right? So the first is this classic deepfake concern. A person appears to say or do something they never said or did. The second, though, is a little bit more nuanced, which is alteration concern. A real video or image is modified in a way that changes its meaning. The third is enhancement concern, right? An image is sharpened or brightened or zoomed or cleaned up or reconstructed in a way that may make uncertain details appear more certain than they are. The fourth is demonstration concern. A lawyer uses AI to create a visual aid or reconstruction or an illustration, and the demonstrative begins to feel like substantive evidence because it's so high quality and it's so cool to look at. And this last category is extremely important because AI-generated demonstratives are very useful and they may explain complex facts, but the jury has to understand what they are. A demonstrative is not the event, right? A reconstruction is not the event. A generated visual is not the event. The line between explanation and persuasion can become blurry very quickly. And that is why the phrase visual authority matters, right? AI can create visual authority. It can create something that looks official or polished or forensic or documentary, but visual authority is not the same as evidentiary reliability. So for lawyers, the response should be disciplined rather than panicked, right? We have to ask, again, who created this? What was the source material? Was AI used? If AI was used, for what purpose? Is there an original? Was it preserved? The courtroom risk is not only that the jury will believe a completely fake video. The more common risk is that the jury will overvalue something that is only partially reliable, right? A cropped clip or a compressed video or an enhanced image or something like that, right? A viral video with no provenance. So the AI shift is not a reason to abandon visual evidence. It's a reason to become more exacting about visual evidence. The question is not, can this be faked? In the abstract, anything can be faked. The better question is, what foundation makes this trustworthy enough to use in court? And so let's go to the next slide because I want to get into the sort of core rules of evidence. Right, these are the core rules of evidence are things that we are all already familiar with. And let's start with Rule 901, because Authentication is the gateway. The proponent must produce evidence sufficient to support a finding that the evidence, that this item that we're trying to give in front of the jury is what the proponent claims it is. So that phrase, what the proponent claims it is doing a lot of work. With visual evidence, the claim might be simple or complicated. If the proponent says, this is a photograph I took with my phone at 3 p.m. yesterday, that's one kind of foundation. If the proponent says, this is a still image extracted from a surveillance video that was exported by a vendor from a building security system and then enhanced for brightness, that's a different foundation. If the proponent says this is a screenshot of a social media post, that's a different foundation. And if the proponent says this is an AI-generated demonstrative showing how an event might have occurred, that's something else entirely. So the authentication burden changes with the claim. Rule 901 does not require the proponent to prove authenticity beyond all doubt. It's a threshold rule, but the threshold still matters. The court needs enough evidence to support a finding that the item is what it claimed to be. Next is Rule 403, because even authenticated evidence can be excluded if its probative value is substantially outweighed by dangers like unfair prejudice or confusing the issues or misleading the jury or undue delay or wasting time. And visual evidence can be especially powerful under Rule 403 because it can create confidence that exceeds its reliability. A video can be authentic but incomplete. A photograph can be real but misleading. A demonstrative can be helpful but too polished. An enhancement can clarify but also overstate. And so the 403 problem is not always that the evidence is false. Sometimes the problem is that the evidence invites the jury to give it more weight than it deserves. And then there's Rule 1002, the best evidence rule. If a party is trying to prove the content of a writing or recording or photograph, the original is generally required unless the rules provide otherwise. In the digital context, this can become complicated. What is the original of a video? Is it the native file on a phone? Is it the cloud export? Is it the platform download? Is it a PDF containing screenshots? These are not technicalities. These may determine whether the court is looking at the most reliable version of the evidence. And Rule 702 comes in when the technical issues require expert testimony. A lay witness may be able to say, I took this photograph, or this video fairly and accurately depicts what I saw, but a lay witness may not be competent to explain metadata or compression artifacts or frame interpolation or audio synchronization, right? A lay person may not be able to talk about editing or deepfake indicators. And it doesn't mean that every case needs an expert. It just means that lawyers should know when they are outside ordinary lay knowledge. And finally, chain of custody and metadata are the practical bridge between doctrine and facts, right? Metadata may show creation date and modification date and other information. Chain of custody shows who had the file and how it was preserved and whether it was handled reliably. But neither metadata nor chain of custody is magic, right? Metadata can be stripped or altered. Chain of custody can be imperfect, but both lawyers give a disciplined way to test reliability. So the overall point is that AI does not make evidence law obsolete. It makes evidence law more important. We all have to know these rules and rely on them even more. Let's go to the next slide 6, because this slide is a practical checklist. When you receive, I want to think about when do we use these rules, and when you receive visual evidence, the first question is, who created it? And it sounds obvious, but it's often the key question. Did the witness take the photograph? Did the client record the video? Did a building security system capture it? Did a police body camera capture it? Did a third-party vendor export it? Did it come from social media? Did it come from a group chat or an anonymous source? The more direct the source, the easier the foundation may be. The more remote the source, the more careful the lawyer needs to be. Second, when and where was it captured, right? Time and location are not background details. They can be central to authenticity and relevance. A video of the right person at the wrong time may be useless. A photograph of the right place on the wrong day may be misleading, right? A screenshot may appear to show a conversation, but the date, time, and sender and recipient and platform may all matter. So you have to think about when and where it was captured, right? Third, what device or platform produced it? An iPhone photo or a Ring camera clip or a Zoom recording or a video from TikTok or WhatsApp or whatever. These are all different evidentiary objects. They preserve different information. They strip different information. They compress differently, and they generate different metadata. They all have different vulnerabilities. Fourth, was it edited or enhanced or compressed or converted or reposted? This is where precision matters. I mean, edited does not automatically mean fake. Cropping may be legitimate. Brightness adjustment may be legitimate, right? But the court and the party needs to know what happened. If a video was brightened, say so. If a clip was excerpted, say so. So the issue is whether the change is disclosed and understood and property limited. It's not whether any change is fatal. Fifth, how will you authenticate it? And there's several different possible paths. A witness with personal knowledge may authenticate it. Metadata may support authentication. A custodian or platform witness may support authentication. A forensic expert may be needed, and sometimes a combination is best. So the key is to choose the authentication path early. So from a practical standpoint, I would recommend a simple intake protocol for visual evidence. Ask for the native file. Do not settle for a screenshot if a source file exists. Preserve the file as received. Do not casually forward it around, right? Record who provided it. Record how they got it. Ask whether there's a longer version, whether there's audio, whether there are related files, whether it was edited. It's not just good litigation technology practice, it's good litigation practice. And judges notice when one side is disciplined. If one side says, here's a video our client sent us, and the other side says, here's the native file, here's the device, here's the date, here's the chain of custody, here's the metadata, here's the witness, here's exactly what changed and what did not. The second side is in a much stronger position. So it's not about being a technologist, it's about being a careful lawyer. Let's go to the next slide. I want to talk about red flags. A red flag does not always mean the evidence is fake, because that's important. Lawyers should not overclaim. A red flag means the evidence deserves pressure. It means there are questions to ask, discovery to seek, and possible motion practice to consider. So the first red flag is unclear provenance. Provenance means history of evidence. Where did it come from? Who had it? How did it move from the source to the lawyer to the court? If the answer is vague, someone sent it to us, it came from a group chat, it doesn't make it inadmissible automatically, but it means the proponent should be required to explain more. Second red flag is missing metadata. Missing metadata is not proof of misconduct. Many platforms strip metadata automatically. Screenshots do not contain the same metadata as original files. Files sent by text or posted online may lose information, but if the proponent wants the court to treat the item as original or highly reliable, missing metadata may matter. The third red flag is a screen recording of the original media. Now, this is common. Someone plays a video on one phone and records it with another phone. Now the evidence is not the video itself, it's a recording of the playback of the video. And that raises questions. Where is the original? Why was a screen recording made? Was the recording complete? And the fourth red flag is cropping or context-free excerpting, right? A short clip can be authentic and still misleading. If the event lasted 30 minutes and the clip is 8 seconds, the issue may not be whether a clip is real, the issue may be whether it's fair. The lawyer should ask for the full recording, the surrounding footage, and the circumstances before and after the clip. The fifth red flag is viral internet content with no reliable source. Because virality does not authenticate. The fact that a video was widely shared may prove that it was circulated, but it doesn't prove that the video is real or the date is correct, right? It doesn't prove that the person shown is who the people claim it is. And the sixth red flag is AI artifacting or visual inconsistency, strange lighting, inconsistent shadows, audio that does not sync, visual instability across frames. But lawyers need to be careful here because human beings are not reliable deepfake detectors. Some real videos look odd. Some fake videos look clean. So don't just say this could be AI. It sounds speculative. Say instead, the proponent has not produced the original file. The only version is a screen recording. There is no metadata. The clip is excerpted from a longer recording. The source witness cannot explain how it was created. The risk of misleading the jury is substantial unless the foundation is established. And that is much stronger, and it ties the technology concern to evidence doctrine. It gives the court a concrete problem to solve and avoids sounding like you're using AI as a generic scare word. Let's go to the next slide, please. Also, maybe you could just let me know how much time we have left in our presentation here, if you can.
Just currently 10:31.
Okay, so I'm going to do one more slide then, because I think I only have enough time to do one more slide, if that's okay. I'm going to just do a practical litigation playbook, and then we'll leave it at this, and we'll see if we have any time left at the end of this. This is the playbook slide, right? If you were dealing with visual evidence, the first move is to ask for the original file. Not a screenshot, not a PDF, not a repost, not a texted copy, not a compressed version, not a still image. Right? Ask for the original file in native format with metadata preserved if possible. If the other side does not have the original, that is not necessarily fatal, but it matters. Why don't they have it? Who does? Was it lost? Was it overwritten? Was it downloaded from a platform? Was it exported? Second, preserve the provenance and the metadata and the chain of custody immediately. This applies to both sides. If your client sends you a video, do not destroy its evidentiary value by handling it casually. Save the original. Record how you received it and keep a clean copy of it. Avoid unnecessary conversations. Ask the client not to edit or crop or rename it or run it through enhancement tools unless there's a reason and the process is documented. Third, compare versions of it. Often there's more than one version of the same evidence. There may be a raw file, a texted copy, a social media version, a shorter clip, a longer clip, and you may learn what was cropped or what was lost or what was added or what changed. Fourth, decide whether the fight is about authenticity or completeness or expert interpretation or prejudice, right? These are different objections and they should not be blurred together. An authenticity argument says, we do not know that this is what the proponent claims it is. A completeness argument says, this may be real, but it's misleading without the rest, right? So a 403 argument says, the evidence persuasive force exceeds its reliable probative value, and the jury may be misled. A 702 argument says, the jury cannot properly evaluate this technical issue without expert help. A best evidence argument says, if the context of the recording is being proved, we need the original or a proper explanation for its absence. Fifth, use stipulations and limiting instructions where appropriate. I think we all know that not every issue requires a war. Sometimes the parties can stipulate that a video is authentic while at the same time reserving disputes about interpretation or context. Sometimes a limiting instruction can reduce prejudice. Sometimes the answer is to admit the full recording rather than a clip. Sometimes the answer is to identify a demonstrative clearly as demonstrative. And sixth, consider experts early. A forensic expert can help determine whether a file has been edited, whether the metadata is consistent, whether audio and video are synchronized, whether compression artifacts explain anomalies, whether a file is likely a derivative copy, and whether AI indicators are present or absent. Do not wait until trial to discover that you need that analysis. The governing mindset is this, and let me leave you with this. Treat visual evidence as a source to be tested, not a story to be accepted, right? This applies whether you are offering the evidence or attacking it. If you are offering it, build a clean foundation. If you are challenging it, identify concrete reliability gaps. Either way, the goal is precision. My name is Duncan Levin. It's been a pleasure to present this to you today. I really appreciate the opportunity to appear here. I'm sorry I don't have more time. I could talk about this all day. I'm sorry I don't have more time today, but it's been a pleasure. Thank you for the invitation to address you here today. And I wish you all good luck in the age of AI with your trial handbooks. Thank you so much.
This concludes today's presentation. Thank you so much, Duncan, for an excellent presentation today. And thank you so much to our audience for joining us. Have a great day, everybody.